Hey everyone, welcome to the Leading Ladies conversation. This is part one of a series that's going to be going on throughout 2020. We're super excited to have Ortmann be joining with us and bringing all this amazing content to us. Just wanted to take a few seconds to be sure that we have everything under order for everybody. If you are wanting to ask a question throughout the webinar, there is a button on your participants box. So if you are on your Zoom screen and if it's like already at a full screen, you can bring your mouse all the way up to the top of it and you'll see a window pop down that says Manage Participants or Participants. You'll click on that. It'll give you the list of everything. You'll have the option to raise your hand. It's one of the options in More. Or actually, no, just right at the very bottom, it just says raise hand. And you can notify us that way that you are wanting to ask a question, and that way somebody will eventually ask you to join the conversation, and I will manually unmute you at that point. So if you need anything, feel free to do that. Otherwise, you can use the chat option, and I can relay your questions at the very end of the presentation. With that said, also, if you would like to unmute yourself during that process, you can hit *6. With that, I think I'm going to go ahead and introduce Kathleen and Jennifer, who are going to be presenting this amazing content over. If you guys want to go ahead, I'm going to take down this slide so that you can start sharing your slides.
Okay, hold on. We've got, let me see. Perfect.
And you're good. You're live. Thank you.
Great. Can everyone hear us first?
I can hear you.
Great. Hello. Good afternoon, everyone. My name is Kathleen Smith. I am a partner at Ortmann. We are a law firm that is dedicated to the construction industry, and I have with me my colleague Jennifer Tung, who has been with us for the past 6 years. And we are doing this inaugural series of the Leading Ladies, but I wanted to take just a minute to talk a little bit about Ortmann and the reason why we love giving these types of presentations is that we're one of the unique breeds within the legal construction community in that we actually represent everyone with any role or responsibility within the construction industry. So we represent designers, contractors, owners, subcontractors, suppliers, and we have a unique perspective on all of the legal issues that can come out of your construction projects. And Jennifer has been very involved in the USGBC and has brought me along the way to be a part of this Leading Ladies seminar. And I'm very excited, and I hope that you all are excited about what we have to share, because I know that most of you probably don't love talking to your lawyers, and so we're hoping to dispel some of the criticisms that you may have about your lawyers and the legal profession in general. But we've been doing this. I've been practicing law for 15 years. Jennifer's been practicing for 9, and most of that time, for the last 11 years, I've been practicing within the construction industry. And we're just really excited to get this started. That is me, to put a picture to the voice. Like I said, I've been with Ortmann for 11 years. Jennifer has been trailblazing in the environmental capacity for a long time, was even a political organizer, and has a lot to say about the policy side of a lot of the green building initiatives that we see in California right now. So I'm going to hand the reins over to Jennifer for just a little bit to talk a little bit more about the series.
So thank you, Kathleen, and welcome everyone to our premiere episode of Leading Ladies, Conversations on Construction. As was mentioned earlier, we'll be bringing these to you quarterly, at least through 2020. And, we aren't contractors and we aren't designers, we're lawyers. So we wanted to bring, that perspective to you in a digestible, bite-sized morsel throughout the year. And, we have our ideas of what we think are important issues, based on what we most commonly see among our clients. But what we want most for this series is for it to be helpful to you as the viewers and the listeners and the members. And so, if there are topics that, that you find that you're coming across a lot out in the field that you really want to know more about, please, by all means, feel free to email us, and we'll have our emails for you at the end of the presentation. Feel free to reach out to us and let us know what you'd like to hear more of. We really want this to be a collaborative experience. And that goes for during this webinar as well. As was mentioned earlier, there's a raise your hand button. So if at any point during our presentation you guys have questions about something, feel free to raise your hand, and we'll call on you, and you can go ahead and ask a question. And again, we want to hear from you, because oftentimes as lawyers, we won't hear about the kinds of disputes you're experiencing on projects until years later, just because there's a bit of a natural lag. Projects often take a while. Parties will try and work things out informally, before they come to us, and so oftentimes, we hear about things, years down the road. So if you guys are experiencing specific types of issues, here and now, again, feel free to reach out to us and let us know.
All right, without further ado, we do want to get into the substance. And so today we've actually decided that we're going to start, with the basics, Contracts 101. But I say basics, but want to emphasize that pretty much nothing in connection with construction contracts or design contracts is ever basic. This is one of those fields that it takes a lot of understanding and a lot of diligence to grapple with some of the concepts that are happening and to draft documents that are appropriate for your project and are appropriate for the level of risk that you're taking on. And by no means do I want to say basic in the concept that these are uncomplicated. In fact, these issues are at the heart of many construction disputes, as we'll see. And so I wanted to start with what a contract really is. Contracts are used to identify the roles and responsibilities of the parties within a particular contract. And there are a lot of ways in which you can do it. The best way, obviously, is to have some kind of written agreement that is negotiated and understood by the parties. One of the major characteristics that we emphasize is the risk allocation components of your contract. And what that really means is that not only are you taking into account what responsibilities you have to produce a particular set of working drawings or contracts or construction, we really want to take that a next step and look forward and identify what responsibilities and identify the attendant risk. And make sure that as you're moving forward within your industry, that you're actually pairing those things together at a very early stage. Because if your responsibility is very high, but your risk is even greater, there is an imbalance that could potentially cause a lot of problems as the project progresses. Now, one of the things that I also talk to my clients quite a bit about is using the contracts to manage expectations. And as we get a little further into the presentation today, we will be talking specifically about what the expectations are and some of the ways in which, especially with the influx of green building and some of the newness that is coming with some of the changed responsibilities, that this particular area is of critical importance to make sure that when the agreements are reached and the contracts are signed, that people do really have not only a good understanding about what their expectation is for the work that they're going to perform, but they also know the roles and responsibilities of the other side, and that there is a good coming together of that kind of information so that the project is successful, not that you're just walking out with, a profit, which is obviously great, but you also want to have a great, set of working relationship during the process. So obviously, legally speaking, what's a contract? It's a deal. A deal is a deal. You think that you're going to set forth everything that you need to know, but like all things, there's always some complications. So equally important to what a contract is what a contract is not. Contracts are not a one-size-fits-all kind of deal. I'm often asked to either negotiate or draft contracts for my clients, and whether you have your attorney draft contracts for you so that you just have a cachet of forms that you can look to, or you're going to some of the more trusted form contracts like the AIA or consensus docs. You really need to make sure that with each new project, you revisit all of those standard contract terms and make sure that those terms are the right fit for your project. The next point is that they're not omniscient or prognostications of what will happen. I have found that with time, the contracts that I wrote, my second or third year at Ortmann, have been revised quite a bit to reflect certain experiences that my clients have had in the field, or case law that has come down that has shifted some of the landscape. So it is really important that we not get too complacent and use our standard contracts as something that's going to be a perfect document. It's never going to be. It's never going to always cover every possible scenario that could happen.
And just to chime in briefly, that's true also for form contracts that you order, whether it's AIA or consensus docs. Those are great starting points. And if you're going to use one of those, you should always go through with a professional and make sure it's properly tailored to what you need.
That's right. And another thing that I have to sometimes remind my clients is that contracts are not self-executing. There are a lot of reasons why there are important provisions that are put into contracts, and you hope that everybody lives and abides by them. But there are often business reasons why people intentionally break contracts. And, just because a contract says that a particular process is going to be used or a particular risk is assigned to one person and not the other, doesn't mean that that always happens. And I have seen in a lot of my, over the course of my career, the way in which, the conduct in the field doesn't match what the, process was supposed to have been, if you followed the contract to a T. So it's one of those documents that it gives you the guide, and if you live by it, that's great. But when you have to use its terms to enforce a particular provision, you're going to have to fight. It's not going to automatically be so simply because Article 17 says. So I wouldn't be myself if I wasn't a true lawyer and recognize that you also don't want contracts to be a one-size-fits-all or self-executing, because that kind of takes, some of the fun out of the game, because, even as the Dalai Lama has identified, is that, knowing the rules well so that you can break them effectively. Not self-executing, but you need to have some maneuverability within these terms, knowing that words are imprecise and that construction projects in particular are so complicated that you need to have some ability to maneuver, because you don't know what to expect, and you just hope that you at least have a good relationship with your contracting partner, that you can, do the right kind of dance to get to a successful project. But even beyond that, the importance of knowing your rights and responsibilities is preeminent. There have been numerous studies that have evaluated construction claims all over the globe and within North America. And very consistently, one of the most common causes for disputes are either errors and omissions in the plans for a project, or the parties' failures to understand and comply with the contract terms. I will tell you that something that was very interesting when I was going over this is that although in North America the second most common reason for construction claims is the failure to understand and comply with contract terms, worldwide, it's the #1 cause of construction claims. So, being prepared and understanding what your rights are, is more than half of the game. Now, to put some of this into perspective and to talk about design responsibility, we have to talk a little bit about the legal backdrop that is always present when you're dealing with any kind of design responsibility analysis. And that is a construction case that goes back to 1918 that was decided by the United States Supreme Court and is applicable in California, despite this being a federal case. The classic statement for the Ferrin doctrine, which it's known by, is the owner impliedly warrants the adequacy of the plans and specifications when the project commences, and any liability that arises from incomplete plans and specifications is borne by the owner. Now, we all know that we don't live in a world where full sentences are valued, and so, of course, there's got to be a Twitter statement for Ferrin. Now, I do want to take some liberties with what Mr. DeVries has said, is that, so according to him, owner designs, contractor builds, owner accepts, work sucks, owner sues, contractor absolved, owner loses. The whole work sucks component opens up a whole different ballgame of, causation and whether or not we're talking about design errors or construction problems and ineffective performance. But, I'll give him a lot of credit for being able to, Twitterize, Ferrin. And now, obviously, what you've seen is that the Ferrin doctrine very much looks at the context between the contractor and the owner, and essentially talks about the way in which an owner is going to be responsible for any kind of design errors that relate to the contractor's performance of work. But obviously, when we are talking about who's going to own that kind of responsibility as between the owner and the contractor, we also have to be very aware that should the owner be held to be responsible for any errors and omissions or some ambiguity or incompleteness of the plans, that the owner is then going to look to its design team for some kind of indemnity or a potential breach of contract or something in that realm. So we can't look away from Ferrin and not at least understand that there is already in place an entire legal doctrine that ascribes responsibility to the owner if the contractor encounters some problems in its construction during the project. So when we move into more of the design world, we do have to recognize that Ferrin is the backdrop. And should there be no additional provision within the contract or any other admonitions that are given during the contract and negotiations, that doctrine is going to apply. And should there be any issues with the completeness or the adequacy of the plans, courts are going to look to some of the public policy that is behind the Ferrin doctrine in order to evaluate what the roles and responsibilities were. So what does that actually mean? Well, that means that when the contract is silent, you are going to live under the veil of Ferrin. But what you'll also see is that there's going to be what we call a common law standard of care, which is going to evaluate any kind of designer's performance in the preparation of the plans and specifications and analyze that against reasonable care, the technical skill and ability, and ordinary diligence of a professional in the same locality and within the same field. So obviously that's a mouthful for essentially saying that any designer is going to be compared against his or her peers when evaluating whether they have lived up to his or her design responsibility. And it is not an easy concept, and it is not a black and white one, and it is often very costly for participants in lawsuits that are dealing with standards of care because it's a very expert-driven type of analysis and is very much driven by the facts of the case. When you get into standard of care legal disputes, often these are costly lawsuits that, dive into every detail that goes into the planning and the performance of the design. Now, what some owners have done is that they have not liked this kind of median, middle of the road standard of care analysis that's in place should the contract not have any kind of specific call out for a standard of care. So there are ways in which owners can either very clearly or in very subtle ways contract for a higher standard of care from their design professionals. Often you see that within provisions that call for a design professional's best efforts. Sometimes they go into more detail and actually set out some kind of metrics that are going to be used to evaluate whether or not a design professional met his or her obligation. But in that way, it's going to be very important for design professionals to not just look at the standard terms, but they're going to have to look at all of the provisions in their totality to make sure that there isn't some catch in there that will, inadvertently increase the standard of care that they're going to be held to. Now, obviously, a lot of these things aren't very clear. And with the difference in your scope of work, so too will be a different standard of care. Someone who's preparing a conceptual design is not going to be evaluated against the same kinds of decision-making as someone who is being asked to not only put together the conceptual designs, but is also helping in contractor selection or identifying particular materials and equipment to achieve a particular goal by an owner. And in that way, it's going to be one of the hardest parts of the negotiating process is to make sure that as you're putting together your scopes of work, that you really truly understand what that scope of work is and be willing to stay within it to ensure that you're not inadvertently signing yourself up for risks that were not originally contemplated and that certainly aren't, they won't bear out in your costs. So it is incredibly important to pay attention to the scope of work and to pay attention to even what they would consider to be standard terms if, owners are proposing their own sets of terms. Scope of work is one, but as we progress and the rise of alternative project delivery methods increases, there is going to be a shift away from the design, bid, build model where the roles and responsibilities of the design professional, the owner, and the contractor are much clearer. And even within design, bid, build, there are all sorts of ways in which those lines between responsibility and means and methods, or design responsibility and means and methods, can be blurred. Even performance specifications can often cause a lot of problems between designers and contractors, and the scales always tip with specific facts, but what is a means and methods when there has been a specification, a performance specification put into a design, bid, build set of bid documents? Are the submissions enough, the approval of the submittals enough to underwrite all of the decisions that a contractor has made? In some circumstances, yes. But, it is so fact determinative that to have a better understanding of and communicate your understanding of what you are signing on to is so critical when you are dealing with the negotiation of your contract. Design build opens up a whole new Pandora's box about how to divvy up design responsibility, especially when you're dealing with a design build project that has bridging documents. Obviously, the same kind of Ferrin doctrine liability that the design is owned by the owner, has to be modified But when you have bridging documents, you don't completely eliminate Ferrin, because essentially the owner at that point in time, whether you're at the 25, 30, or 35% completion of the project documents, there's going to be questions about how much of the original design impacted whatever error is ultimately discovered.
So to piggyback off of an idea Kathleen had brought up, this idea of contracting for, a higher standard of care, one of the additional risks that come with green building are, when an owner has an overall green, or sustainable building goal. So some owners are, going to want their project to achieve a specific sustainability certification, or, they might want a local tax break, or they might want to ensure some kind of minimum amount of cost savings to operate the building. So assuming the owner wants to achieve a sustainability goal like that, you want your contract to try and capture that goal as accurately as possible. There's no perfect contract, but having one that's as unambiguous as possible ultimately helps to minimize the opportunities for disputes by making sure everyone is on the same page, that everyone understands and agrees what the project is going to be. So you have your awesome contract with your really awesome and accurately described goal. The next question is, do you as the designer guarantee that goal? So if you are the project owner, then yeah, you definitely want your designer to guarantee that goal, because as the owner, you want the project that you believe you paid for. But what if you're the designer? If you're the designer, that's generally not a risk that you're going to want to take on, because, for example, you can't control third parties. So let's say the owner wants a specific LEED certification. You might design the project so that you get all the points possible that you think will get you that LEED certification, but ultimately, that certification is out of your hands. It's up to the USGBC. And so you can't control third parties, including the owners. For example, you have no control over how an owner is going to maintain or operate some kind of sustainable system you've included in your project that you're not, once you're done with the project, you're not even on site anymore to monitor. And so, we talk about this so that you're aware that this is going to likely be a tension that you'll experience on a project, and it'll be something that you'll have to negotiate with the owners if this is a risk that you are going to be willing to take on, if you are willing to take it on, to what degree, and how are you going to ensure that you're compensated fairly for taking on that risk in your contract. So, yet another kind of risk that comes along with green building and sustainable building are what happens with project specifications. We like to talk about this as the blame game and how to win the blame game. So sometimes you're going to be called upon to include, general types of specifications, particular type of material or technology. Other times you're going to be asked to specify, particular brands or models. And those come with their own risks.
Yeah, and I want to just jump in really quickly and talk about, what we mean by this. And so when we're talking about, specifications and calling out types of materials or technologies, what we're talking about is really the or equal components. And so there is some kind of material or some type of particular equipment that the owner has identified is really necessary in order for them to achieve the goals on this particular project, but that they're not necessarily so clear about what they want, and so they are open to suggestion not only from the designers but from the contractors to come to the table and actually identify different types of technologies, information, processes that can actually achieve, the owner's ultimate goal. But in there really does come that concept of or equal. And that is one of those areas in which there's a lot more gray. There's gray because essentially you're looking to a contractor to come to you and say, hey, listen, I can achieve your specific project set of goals using this material. Now, you as a designer, have to know what your role is and what your responsibility is. Are you going to underwrite the contractor's methods? Are you going to be doing your own independent research? Are you going to be going to the manufacturer to make sure that the manufacturer's processes are what the contractor claims them to be? It's going to be very important for you to know how far you have to investigate to ensure that whatever material or whatever equipment is being called out by the contractor is actually going to achieve the goal of the owner. Now, where it's less ambiguous, but there is going to be more risk, is where there is a specific technology or model or brand or something that the designer really truly believes is going to be the only way to get the owner to the finish line. In those instances, there is going to be a more impactful responsibility on the designer to make good decisions, because the owner is going to be, to a certain extent, relying on the skill and the knowledge of the designer to call out a specific method, machine, equipment, system, whatever the case may be, to achieve its goals. And again, obviously there's going to be a lot of research that's involved in making those selections, but there is also a certain amount of responsibility that will be put in the designer's lap to ensure that this was the right type of process, that this was the right type of equipment. That's not to the exclusion of, any manufacturer warranty or anything like that, but when there is a specific call out, especially with some of these new technologies that are emerging within the green building industry, there will often come an additional responsibility to make sure that whatever is being recommended to the owner, has at least a reasonable opportunity of meeting that owner's goal.
And those lessons are applicable across the board when you're talking about making specifications for a green project. Even when you're not presented with an of equal by the contractor, you especially when it comes to these new technologies, try and go with materials and technologies that you have firsthand experience with, so that you know that they hold up to their claims. But if you're going with something that you haven't tried yet before, it's important to do your research. Show that research to the owner to get them to buy in, so that they can't. The goal is basically to make your decision seem as reasonable as possible. And if you get the owner buy-in along the way, they'll have a harder time arguing that, well, they were totally duped or didn't understand what they were getting into. So do your research, share that research with the owner, get buy-in, and no hyperboles. So no talking about anything like this is the greatest sustainable, wood glue ever. You want to steer clear from claims like that have a high likelihood of maybe not living up to those kinds of expectations.
In general, lawyers hate adjectives, so to the extent that you can eliminate adjectives, that's great, because whenever you do things like that and enhance, you're just buying a claim down the road that someone was misled or didn't understand, or that they were persuaded by you to do something against their own interest.
Yes, so if at minimum all you want to do is make your lawyer happy, no adjectives. And like Kathleen said, you try to make your choices as reasonable as possible, but ultimately you are the designer and you're being hired for a specific, professional skill that lay people don't have. And so to a degree, you're not going to be able to disclaim all liability. You will have some responsibility on your shoulders, but try to make your choices seem as reasonable and as thoroughly researched as possible, so that a disproportionate share of that liability doesn't fall into your lap.
And that's right, and that's a really important point to make right now, is that the best contracts are not one-sided contracts where one party to that contract bears no responsibility and the other bears it all. The best contracts are the ones that are well thought out and assign the right risks and the right responsibilities in the right proportion. So here we are at the lessons learned, and one of the things that is always so important is that knowledge is power. That we've talked about the way in which someone else has gone over and analyzed, construction claims worldwide, and pretty consistently what we see is that where the rights and responsibilities and the obligations are well understood, that those particular projects have a better shot of ending at substantial completion instead of going into some kind of dispute resolution posture. That when you are dealing with your projects, that knowing the type of project delivery method that you're working under and understanding how those responsibilities change between a traditional design bid build and a design build and a CM at risk and all of the other variants of contracting methods that are now so popular, that you make sure that you're flexible and that you know how your risks are shifting and who is going to be taking on some of those particular responsibilities. It's one of my favorite sayings in the context of contracts is that an ounce of prevention is worth a pound of cure. And while it is very tough for a lot of people to sit down and read a contract and understand all of the nuances of it and then fight for the particular provisions that make sense within the context of what project you're doing, it is critically important because those tough conversations that you have at the beginning of a project are a lot easier to have when there isn't an immediate need to resolve something. And you set the expectations soon, and then you can move on them. So it is one of those areas in which you just have to buckle down and be thoughtful about your project and figure out what you want out of it and what is a fair allocation of risk to you. Also, green building is, not only showing the way in which new technologies and softwares and processes are possible, but they're taking advantage of the already, strong technology, propensity within construction management. And technology is a useful tool to help project participants work through issues and problem solve. They keep good documentation, accurate records of changes and things like that. But I came across in preparing for today a great quote from Bill Gates that is, the first rule of any technology used in a business is that automation applied to an efficient operation will magnify the efficiency. The second is that automation applied to an inefficient operation will magnify the inefficiency. So as the technologies improve and as we become more dependent on them, it doesn't replace good old-fashioned common sense and organization. That you will be much better prepared for dealing with problems if you already have a good infrastructure within your own team to making sure that you know what's going on and that everybody's informed. And, that generation between the millennials and the Gen Xers. And so I have this healthy dose of what once was and what will be. And, we're maneuvering new landscapes right now. And it's amazing, and I love being on the bleeding edge of all of these amazing technologies. But I don't want people to overlook good old-fashioned reasonableness and relationship building. That if I could impart one fact, one key piece of information that is, a key to success it really has to do with human factors, how you communicate to each other, what you communicate, and doing it reasonably with an eye toward a success to the project as opposed to winning this particular battle. I will tell you that many of my clients who are willing to lose certain battles during a project ultimately win the war because the cost of litigation is enormous. And especially when you're dealing with design responsibilities and errors and omissions and, you know, the breaches of standards of care, that is not just going to be your lawyer fees. It's going to be expert fees, and it can be exponentially more than you think it's going to be. And oftentimes, you know, a good set of communication skills would have gotten you much further than having, you know, a fabulous lawyer, you know, at the other end of a telephone call. So, you know, all of my advice is always, you know, be willing to compromise when there's a compromise that can happen, but stick to your guns when you've got good claims. I don't look at reasonableness as a replacement for, you know, giving away the farm. But the reality is that these are business decisions. Abiding by the contract is a business decision. Breaching the contract is a business decision. And it is so interdependent on the personality of your project and the personality of your project team. So, you know, we've talked about a lot today, and, you know, we're going to stop with our prepared presentation, but we're going to open it up to some questions if anybody has any questions for us. Anybody?
All right, well, if you're feeling, you know, audio shy today, that's okay. You can always email us with questions or other topics that you would like us to discuss. Feel free to reach out to us anytime. I believe our next episode is going to be May 7th. So we hope that you've enjoyed today, that you found it informative, and that you'll come along for episode 2.
All right. Thank you, everyone, for joining us today.
Yes, thank you guys so much. We really appreciate it. This has been super informative. I especially like the bit about not to use adjectives. I found that to be imperative, so thank you guys for this. I am about to share one last slide. Just thanking our sponsors, but also especially thanking you guys, Hunt Ortmann. We really, really appreciate you, Kathleen and Jennifer, for doing all of this today. That was lovely. We can't wait. The next one is supposed to be on May 7th. So we're looking forward to this. If I can get this slide up, that would be a miracle. And then also, if anybody has any questions in these last few minutes as well before we end the meeting, please feel free to do so. Okay, so here we go. So the next one is supposed to be May 7th. The one that we have after that is scheduled for July, and then we have another one on October 15th of this year. Just as general announcements, we also are launching our talent portal today, so we're very excited about that. If you guys are not on the email list, if you want to go ahead to USGBC-LA.org, we are going to be, there's a sign-up list for our mailing list, and that would be pushing out information as to when this is live this afternoon. You'll also be able to stay in touch with when the next Leading Ladies webinars will be. We also have MGBCE coming up again this year. It's going to be on Friday, May 29th and Saturday, May 30th. This year it's a 2-day event. We have Municipal Green, which is the standard MGBCE setting on Friday. And then we're opening it up to the entire community, not just the green building community, on Saturday, May 30th. Both of these days will be hosted at LATTC, so they're going to be outdoors. It should be beautiful. We'll have music and entertainment, family friendly. So we hope to see you there. And otherwise, just thanking our sponsors, especially Hunt Ortmann, for you guys bringing this content for us. That was absolutely amazing, and we really, really appreciate it. And we hope everybody enjoys their day. If you have any questions, follow-up questions, please feel free to email Kathleen and Jennifer. And otherwise, we hope you enjoy and see you at the next one. Thanks so much.
Thank you.
Thank you, guys.
Thank you.